All right. Good afternoon again, everyone. Thank you for that break. I wanted to take an opportunity to review what had been argued this morning and put some things on the record before I enter judgment. I always start in these homicide sentencing hearings by addressing the victim's family. It's always difficult to sit up here as a human being and listen to the pain of other human beings and not be able to offer you some form of comfort. But that is not my job today. My job as a judge. And so what I'm getting ready to say is going to sound cold and calculating to you, and that is because it is. Because the job of the judge is to be a neutral and detached magistrate and enter judgment according to the law and the evidence in the case. Your victim impact statements certainly were moving to me. I certainly understand and appreciate your grief, and I wish that there was something I could either do or say that would relieve that from you. But as you, I'm sure, are aware, that the sentence that is available for Mr. Berkebile is one that you're probably not going to be happy with. And probably, if I gave him a sentence of 50 years, if I could, it would not ease the suffering that you are feeling, and I am very sorry for that. I know that as a human, you have my deepest sympathy, and I'm sorry that you are here. But my sentence does not take into account the value of Grace Ann, because as wonderful as a person I'm sure she was, the law, not only in the state of Tennessee, but in Iron Country, takes any homicide as serious, whether or not the person was a great contributor to society or somebody who had never contributed anything. And so when I talk about these enhancement factors in mitigation, I don't want you to hear me saying that these legal concepts are more important than Grace Ann's life was. It's not. It's just that's not the factors that I consider. So I'm just going to start with that. Now, the court is presented with really three questions today. One is whether or not the defendant should be granted judicial diversion, which would allow him to avoid a conviction on his record and could get this expunged from his record. The court is also tasked with determining the length of the sentence as well as the manner in which that sentence would be served. To begin with, the defendant was convicted by the jury of criminally negligent homicide. That is a Class E felony in Tennessee. The defendant has no prior history, so he is what we call a Range 1 standard offender, which means the possible range of punishment is 1 to 2 years. And this is a 30% sentence offense. And so what that means is if he is ordered to serve a sentence in the penitentiary, he has to serve 30% of that before he's eligible for release. Under the law in Tennessee, since it couldn't be more than a 2-year sentence, it would automatically be released after 30% of that sentence, which is just a little bit over 7 months. And so I'll begin with judicial diversion. The defense is requesting for the opportunity to be placed on judicial diversion. They have submitted a certificate from the Tennessee Bureau of Investigation indicating that he does in fact qualify for judicial diversion. Criminally negligent homicide is an offense that fits under the statute as being eligible for diversion. There's certain factors the court has to consider. One is the defendant's amenability to correction. The defendant has some positive things going on in his life and has, as Mr. Lowe has set forward. He has, as I said, no prior criminal history. He's maintained employment through a good portion of his adult life. He does have family support. Obviously has some mental health issues that could be addressed. So with no prior criminal histories to lean upon, the court certainly must find that he has some amenability to correction. The circumstances of the offense weigh against granting judicial diversion, even though, and I'll talk about this a number of times, I don't believe that this was an intentional or knowing homicide. If so, this would be second or first degree murder. It's still a repeated act where the defendant knew or should have known that his conduct was placing another life in danger. And so I do believe that the circumstances of the offense strongly weigh against granting judicial diversion. As I said, he has no prior criminal record. There's nothing in his social history that would cause the court concern one way or the other. As Mr. Lowe said, there's nothing about his physical health that would weigh one way or the other on that. His mental health, he obviously has some issues that perhaps are treatable, and the deterrent value to others and the defendant, I do believe that this is not a common case for the court to consider. This is the first time I've ever had a case like this, and I think that it probably goes on a lot more than we're aware of. We just rarely find out about it either before or after the death of the victim. And so I do think that this is a behavior that occurs frequently but does not result in death, where there is statements being made online either in a bullying nature or in this case an opportunity or a desire to seek gratification. I do think that it would be less of a deterrent value to others if diversion would be granted in this case. As Mr. Lowe said, I don't imagine Mr. Berkebile would engage in this conduct again. I just don't know. It went on for a long time. Who knows what's going to happen after this? And finally, whether the interest of justice can be served to the public and the defendant by granting judicial diversion. That's really sort of the overriding decision the court has to make. And based upon the facts of this case, I do not believe the interest of justice would be served by granting the defendant judicial diversion. Therefore, I'm going to deny his request for diversion. So the next issue to address is the length of the sentence. In order to determine the length of the sentence, the court, after establishing the range, which I've done is range 1, there are certain enhancement factors the court can consider to give guidance in that length, as well as some mitigating factors. Both sides have argued, so I'm going to go through what has been presented this morning. The first enhancement factor the state has cited under 4035-114 is subsection 4. A victim of the offense is particularly vulnerable because of age or physical or mental disability. I do believe that that enhancement factor applies here because it's been established through the proof the defendant initially selected his relationship with Grace Ann because of their both wrestling with suicidal ideation. And so he knew she was vulnerable, and I disagree with Mr. Lowe that he didn't select her for that reason. I think he absolutely selected her for that because that is how he was getting his sexual release, from that vulnerability. And I think she was particularly vulnerable. I think someone without the struggles that Ms. Sparks was going through would not have been susceptible to the defendant's manipulation. And so I do think that enhancement factor does apply here. The fifth subsection, the defendant treated or allowed a victim to be treated with exceptional cruelty during the commission of the offense. The general public would hear that and think, oh yeah, obviously that's a cruel way to treat somebody. But when you look at the case law on this, usually what we're dealing with here, and you'll mostly find this in death penalty cases where there's been a first-degree murder conviction, it's the person does things with the intent to cause pain to that person. Now, I'm not saying he didn't intend for her to feel what he was expressing as pain, but I don't think when you look at the case law that this comes anywhere close to what other cases have found exceptional cruelty. It's aberrant behavior, and certainly would fall under the definition of cruel, I believe, but under the legal case law that has been established in Tennessee, it doesn't come close to what those cases are contemplating. So I don't find that enhancement factor applies here. Number 6, the personal injuries inflicted upon or the amount of damage to property sustained by or taken from the victim was particularly great. As Mr. Lowe said, that cannot apply here because one of the elements of criminally negligent homicide is the death of the victim. So you have to go beyond that. So I don't think that can apply under the law here. Subsection 7, the offense involved a victim was committed to gratify the defendant's desire for pleasure or excitement. This is one the prosecutors request frequently, particularly in child sex cases, and I don't think ever.
We have to hit the pause button here, so to speak, and hit a break. I have to tell you that it is Hayden Berkebile's lack of criminal history that's saving him today. The maximum punishment for that Class E felony in Tennessee is 6 years. We know he's been given 2. We're going to hear more of the court's rationale when we come back.
.com today.
Thanks for staying with us here at Court TV Live. I'm Julie Grant. Let's go back to Tennessee now. We're hearing the court explain the rationale for the 2-year sentence for defendant Hayden Berkebile. Let's watch.
And I don't think ever have I found that this enhancement factor applies until now. I think this case is exactly what is contemplated by this enhancement factor when our legislature put it in. Mr. Berkebile was clearly engaging this conduct for the purpose of his sexual gratification and desire and pleasure. And it's easy in this case to get confused with the word intentional. I certainly believe Mr. Berkebile intentionally communicated to Grace Ann what he wanted to communicate. I don't think he intended for her death. But I don't think it matters in this case. It's irrelevant whether or not he wanted her to die or didn't want her to die. What is relevant is, did he intend to send these messages, and a person sending those, what was their motivation, what was their intent? And his intent, I believe, and I think it's strongly supported by the record, was to gratify his own desire, regardless of the consequences to Grace Ann. And so that enhancement factor, I think probably for the first time in 11 years, I've actually found that that one applies, but I do believe it applies, is entitled to a great deal of weight. Number 10, the defendant had no hesitation about committing a crime when the risk to human life was high. That enhancement factor cannot apply when you have a named victim in the indictment. It must be danger to somebody other than the named victim. In this case, Grace Ann Sparks was our named victim, and there's no evidence that his behavior created a risk of danger to anyone other than her, so that cannot apply here. Subsection 14, the state argues the defendant abused a position of public or private trust or used a professional license in a manner that significantly facilitated the commission or the fulfillment of the offense. This one, to me, was a close call. I do think Mr. Lowe probably has the better argument on that it was a close personal relationship, more of a peer relationship, though, than what we generally find as a position of trust. When we're talking about a position of private trust, you're usually talking about a parental authority figure or a babysitter or a teacher or something like that. They, even though they had this master and subservient level relationship, I don't think that could be classified as a position of private trust. So I'm going to find that enhancement factor does not apply. And lastly, number 17, the defendant intentionally selected the person against whom the crime was committed or selected the property that was damaged or otherwise affected by the crime in whole or in part because of the actor's belief or perception regarding the race, religion, color, disability, sexual orientation, national origin, ancestry, or gender of that person or the owner or occupant of the property. And so this is basically our hate crime enhancement factor. I certainly get the state's argument about disability, her suicidal ideation being that, and that he certainly selected her for that. But I don't think this is what the legislature was intending when they contemplated this hate crime enhancement factor. So I don't believe that that applies under the law. To summarize the enhancement factors, I do find that subsections 4 and 7 apply and are are entitled to a great deal of weight. The defense has also argued some mitigation, mostly under the sort of the catch-all number 13. Some of these are related to listed enhancement factors under mitigation under 4035-114. The defense argues that the defendant, because his age lacked substantial ability to make wise judgments or sound judgments in this case. The defendant was certainly not old, but he wasn't a juvenile either, and I don't think that his age really played much of a role at all in his judgment in this case. He'd been employed, had graduated from school, and so I don't think his age really had anything at all to do with it, so I don't find that mitigation applies. The defense also argues that he did call the police, and that is true, that he could have just turned his phone off and hope nobody ever says anything to him. And so that was the right thing to do, to call the police, and I will consider that as mitigation. The defense spends a good portion of their time arguing that he had no sustained intent to violate the law. I would disagree with that. I understand your point, Mr. Lowe. I don't think he had a sustained intent for her to die, but I do think he had a sustained intent to continue engaging this behavior with somebody who was extremely vulnerable, and he ought to have been aware that his conduct would lead to the death of Ms. Sparks, and so he committed multiple acts of, if it was such a thing, of attempted criminally negligent homicide, which that's not a crime, but he did it a lot, and it's probably a miracle that it didn't happen earlier than it actually did, the way that they were playing. And so I think he did engage in this intentional conduct for a long time, but I don't disagree with you, Mr. Lowe, that he didn't want her to die. There was a lot of evidence in the messages that they had sent back and forth where he actually was trying to talk her down and tell her that her life was worth living, which is just further baffling to me on why he would, knowing that, would continue to engage in this type of behavior. And Mr. Lowe also argued that he couldn't have known that the risk was any greater at this particular time when she did actually pull the trigger with a bullet in the chamber. But I disagree with that. I think he should have known. She told him that day how close she was, and she would give him these numbers about the depth of depression and how close she was to to suicidal ideation. And she gave the highest numbers that I recall giving, and gave him all kinds of warnings, not the time to push. And yet he did it anyway, and he did it because he simply wanted to have some sexual release. And so when you look at the enhancement factors and the mitigation, I find that the enhancement factors greatly outweigh the mitigation, and therefore the only appropriate length of the sentence would be the maximum sentence of 2 years. So the last issue before judgment is entered is determining the manner in which the defendant should serve this 2-year sentence. I've already denied diversion, but he is eligible for probation. Mr. Lowe argues that he should be granted probation. That would give this court longer time to sort of keep supervision over him, because he will be released fairly quickly on a penitentiary sentence. But the factors the court is supposed to determine under 4035-103 is confinement necessary to protect society by restraining defendant with a long criminal history. Obviously, the defendant has no criminal history prior to this. Therefore, that factor would weigh in favor of the grant of diversion. Is confinement particularly suited as an effective deterrence to others for similar crimes? I don't know that I have really ever relied on that one to send somebody to the penitentiary, but I do think that actually applies here. There has been extensive media coverage of this case. It is a unique and novel case, but as I said, I think this behavior occurs a lot more than is brought before the criminal court in the form of abusive online behavior, either through bullying or this type of direct sexual contact, sexual messages. The court frequently is exposed to online predatory behavior toward children, and so I do believe that confinement sentence, when it's this type of an event where somebody is using the internet to engage in behavior that is destructive to other human beings, I think that does weigh in favor of confinement. Have measures less restrictive frequently or recently been tried unsuccessfully? Obviously, no. He's never been on probation before or been in the penitentiary. That weighs in favor of probation. And what's his potential, lack of potential for rehabilitation? That, again, is a difficult one for this court to assess. He obviously does have some mental health and emotional needs that could be addressed through counseling. I do believe he's sincere in his remorse. And so I think he probably is amenable to some form of rehabilitation. And lastly, is confinement necessary to avoid deprecating the seriousness of the offense? And I certainly find that that weighs in favor of confinement. This wasn't an isolated incident. The only thing that was isolated about it is on this particular day, the round in the gun happened to be in the chamber that was getting ready to fall in front of the hammer. That's the only thing that was isolated in this over the last couple of years of Grace Ann's life. And so I believe that the position the defendant was in as far as being the master to a subservient young girl, knowing that she was particularly vulnerable because not only of her age, but more particularly because of her emotional frailty, that he would use that this whole idea of somebody committing suicide to achieve sexual release is the height of evilness in this court's mind. And I believe that if the law permitted, a sentence of 2 years would be warranted. Greater than 2 years would be warranted. However, I'm limited by the law to 2 years. And the family expressed a word several of you talked about being in prison. And I understand that. And it's not my job to give you any spiritual advice, but several of you talked about your faith in God and how he calls you to forgive. Whether or not you forgive Mr. Berkebile has nothing to do with what I do as a judge. You can get up here and say, Judge, be lenient, let him go, and I'm going to do the same thing. Or you can say, I want him a life sentence, and I'm going to do whatever I'm going to do under the law. But one thing that I will tell you, forgiveness generally has more to do with releasing yourself than him. If you let this man and his evilness consume the rest of your lives, then he's going to do more harm to you than he already has. Now, that's up to you how you want to relate to him and deal with him. But one thing I might encourage you on, I've had several people sitting there where you are over the last 27 years of being involved in the system. And some of them have seen something in the system that can be changed. And I know that you don't live here in Tennessee. Most of you don't live here in Tennessee. But one of the things that brings relief to some of the victims' families is they've become advocates and support for other people. And I believe that this case, as well as others, could be an effective springboard to get the law changed for this type of online abusive behavior. And so I would encourage you to explore that. I'm a member of the judiciary. I'm not a member of the legislature, so I have no role in that. I certainly would encourage the legislature to look at these type of offenses and realize the danger that these type of internet abuses are having, not only on children, but on adults as well, too. And so all that being said, the court does find that the appropriate sentence is the maximum under the law, 2 years to serve. So at this time, Mr. Berkebile, if you'd stand up, I'm going to enter judgment. Hayden Jennings Berkebile, docket number 117131, after being found guilty by a jury of your peers of criminally negligent homicide, the court now sentences you to a maximum sentence of 2 years to serve as a range 1 standard offender. In Tennessee, you have to serve 30% of that, and you will be released after 7 months and 6 days. You've already served 91 days of that, which you will be given credit for. So you can have a seat now, sir. Now, Mr. Lowe, I am certainly aware that he is going to quickly get to his release eligibility date as a determinate release offender, and I understand you're going to ask for it.
So with that, Hayden Berkebile goes away for 2 years. As I told you before, his lack of criminal history is what saves him under Tennessee law, because they do grids for their sentencing, and somebody who commits the type of felony he does, who has a record, could have to face a lot more potential time. But With his no criminal history, the big goose egg on those guidelines, he's eligible for probation or up to only 2 years behind bars. So we saw this judge giving him the maximum allowable penalty because of his history and because of the nature of the crime. And he does get credit for time served. That's just the way it is. If you're incarcerated on a crime, as you head to the point of trial, you get credit for that time. So he'll receive that time that he's entitled to for the crime he committed, and then be out sometime in the near future.